that somebody asked me about at the break, and most of you guys probably know this, but there's a consequence for failure to make reasonable efforts, right? Everybody knows that. What is the consequence of a judge making a finding that the agency did not make reasonable efforts to effect reunification? Funding, for refunding, for how long? There's a difference. If the judge makes a finding that the department did not make reasonable efforts to avoid removal, then that child is denied full refunding, the state is denied full refunding for that child for the entire episode in care. Whether that's 6 days, 6 years, whether the child is subject to normal per diem cost or is a special needs child that could cost hundreds of dollars a day. Doesn't matter. The entire episode in care, you can't fix it. Okay? Now, the failure to make reasonable efforts to reunite families or achieve an alternative form of permanency, including finalizing adoptions, can be remedied. It can be corrected. If the judge makes the finding, though, that the agency is not supposed to draw down full refunding for that child. And I put in my orders, I direct, our SAG drafts our orders, and I direct him to put in the order that the department is directed not to draw down full refunding. He always objects and says, I don't have the authority to do that, and I overrule his objection, tell him to put it in there anyway. I don't know if I do or not, but I know that they're not supposed to draw it down under those circumstances. So it's a pretty harsh penalty. Okay? Now the case plan has to be filed within 30 days, right? Now, just by the way, I make some things up, but when I make things up, I tell you that's mine and not somebody else's. But this is the law. This is straight out of the statute. Has to be filed within 30 days, determined at a meeting involving the agency, the parents, and the child. How often does that happen? How often is the child at the case planning session? Depends on the age of the child. Do you know what's your role? Child's attorney? So are you sometimes involved in that process? Pardon? You attend all of them? Okay. I think that may be fairly unusual in the state for the child or the child's representative to be present at the meeting to develop a case plan. Okay. The parents are entitled to 5 days advance written notice. I don't think many parents get that notice. That's what I'm hearing. People just don't pay a lot of attention to that requirement. Kind of what I'm told is that happens in most case planning is a meeting is set up at some point for the parent to come to DFAC's office, and they write up they write up a case plan, and then mom leaves, and at some point the case manager enters it in shines, and then at some point, maybe the day before it's due, mom comes back in, they say, here, sign here. And that's how case plans are developed. It's supposed to be more formal than that. Again, the parents are entitled to 5 days advance notice of the meeting to develop the case plan. The parent has a right to be there, and the child has a right to be there or be represented by guardian ad litem or attorney. And it must contain dissenting recommendations where applicable. That would be if the parents dissent, as an example, the child's attorney dissents. Now, the things the reunification plan must include is each reason requiring removal. As I mentioned earlier, that should come from the court order at the 72-hour hearing. The purpose the child was placed in foster care, why the child cannot be protected at home, and the harm which might occur at home. And that's the piece we miss too. We'll say the child can't stay at home because mom abuses drugs. Okay. If we took the children from every parent in Troup County, Georgia, smoked dope, we'd shut the state down. We'd take all your case managers, because there are a lot of them out there smoke dope. That's not really the question. What is the specific harm that the child may suffer at home if the child is not removed? Description of the services offered and provided to prevent removal. Discussion is how the plan is designed to achieve a placement that is in a safe setting, least restrictive, most family-like, most appropriate, in close proximity to the child's home. And you can kind of fill in the boxes on shines and get this stuff in there in some fashion. So you filled in a box. But there needs to be much more than that. I never see a discussion about these things in case plans. That's what's called for by the statute. And consistent with the child's best interest and special needs. A clear description of specific actions to be taken by the parents. Talk about that in more detail in just a few minutes, but that's the legal requirement, a clear description of specific actions to be taken by the parents. A clear description of specific services to be provided by the agency. Specific time frames. I like timeliness, but I didn't make this up. It's in the statute, specific time frames. The responsible person within the agency. Consideration of a reasonable visitation schedule which allows meaningful contact through personal visits, phone calls, and letters. Has to be filed with the court and made a court order. I will tell you that, I guess my folks may watch this, but I'll go ahead and say it anyway. But, you know, we had a big issue at our stakeholder meeting recently about the supervisors not wanting to sign off on case plans. And I just directed my court staff not to accept any case plans that have not been signed off on by the parent, by the case manager, and by the supervisor. And we had a really big issue about it because apparently it's a really big deal to sign off on case plans. And again, I've got a great office. I've got good folks working there. But the reason I want it signed off on is I want ownership. I don't want somebody to, I was told that the case manager cannot print out the case plan as a final case plan unless the supervisors approved it on shines. Well, I don't know about that. Anybody can push a button. I want somebody to sign it and put their name on it. That's why I require that. It must be served on the parents at the same time as filed with the court. Okay. And it's all about outcomes. And outcomes are a process of philosophy. Now, what do we mean by that? How can outcomes in these cases be a product of philosophy? And whose philosophy are we talking about? We talked about standards earlier, meeting certain standards. That may not be the same thing as philosophy, although I think standards reflect the philosophy of the person setting those standards or the people setting those standards, right? So how do standards come? Who sets standards? Let's say the standard for removal. Who sets that standard? I say the courts. I say courts, I said state, right? Now, one thing, you live in your own little community, you think everybody does it like you. Most of our cases come into care, not all, but most come into care through emergency removals. Not petitions that are filed and that are hearing, not affidavits submitted by defects requesting a shelter care order, but by emergency hearings, law enforcement removal. That in part is as a result of having a strong protocol. So the law enforcement and defects work together, and law enforcement happens to affect the removals. Ultimately, I think that kind of the standard, the standard for removal should reflect the philosophy and beliefs and values of all the stakeholders involved in the process. It's really ultimately reflected in the judge's philosophies, the judge's views. Because if you pull a child and the judge says that child shouldn't have been pulled and we return the child home, then the judge has lowered the threshold for removal. I don't want to say standard, but certainly the threshold for removal. That's one reason judges need to be consistent. Now, we can be consistent. Sometimes we get accused of being all over the board. But, we're looking at individual cases. But judges need to be consistent in how they make these decisions to give guidance to everybody in the system. But the outcome should be the product of the philosophy of all the stakeholders working together and of the process. No matter how you do business, your policies, your protocols, your procedures, and of the people. The outcomes are a factor of the people we serve and the people that serve those people. We have different demographics. In my county, over 65% of the children in our public school system receives free or subsidized lunches. A lot of poverty in my county. Some of you others probably don't have that. So our outcomes in an individual county, and we know what poverty does for these issues and what a major contribution poverty makes to these issues in child welfare. So if you have a county like mine with a lot of poverty, then our outcomes will look different than a county with not as much poverty. That's just one example of it. Now, I'll give you these real quick. These are my 10 steps to problem solving. Because We are problem-solving courts. We're different than superior courts and state courts and a lot of other courts. Because with all due respect to the judges on those benches, they have hard jobs, but they call balls and strikes. They hear evidence, the game's over, it's done. Okay? They move on literally to the next case. They render a judgment, they impose a sentence, and then that's the end of it. They have no ongoing responsibilities in that case. But we are in the business of problem solving from the time the case is filed until after the child's adjudicated, that case leaves the system. So our work is different. And this relates particularly, I think, to case planning. These things are made up. You can buy them or not. Get the right people and information at the table. You know, we know in the case planning, the minimum people at the table need to be there. The agency, the parent, and the child has a right to be there. But that doesn't say who has to be there. That's not a limitation. Other people can be involved, such as relatives. One of the great things that happens in these family team meetings, and a lot of our case plans are growing out of those family team meetings that are held within 9 days of the removal of the child. So it's getting the right people and the right information to the table. And that's whether we're developing a case plan, reviewing the case plan, or making decisions based on the case plan. Understand the roles, rights, responsibilities, and authority of participants. It's important in case planning to understand that though we have taken these children from their parents, the parents still have a role to play. And their role should be very much respected and acknowledged in the process. Define the problem and reduce it to writing in clear, concise terms. That's the judge's responsibility ultimately. In case planning, it's the judge's responsibility. And that's done again at the 72-hour hearing. Reduced, entered in the order, and if you have a good practice, everybody leaves with a copy of that order that day at the 72-hour hearing. Or the adjudicatory hearing if you do it later. Take ownership in the problem and the solution. Everybody should own the problem. It's not just the case manager's problem, it's not just the parent's problem. We're in this business because we want to solve the problems. All those problems belong to us as a system, and we need to own the problem and the solution, and not blame one another for what goes wrong in the system. Set specific achievable goals, identify steps to achieve those goals, assign responsibility for completing steps. All this is just basic case planning as well as other problem solving. Build in monitoring and accountability. Remain flexible because these things change. A lot of times a child will come into care on what we think is medical neglect, and we find out down the road mom has serious mental impairment, mom has a substance abuse problem, mom is impaired at least temporarily because of serious domestic violence issues going on in the home. Maybe the other adult in the home will not let her take the children to the doctor or buy medicine. And we celebrate successes all along the way. That's really important in any problem solving. We're going to talk about milestones later, milestones in our family plan, our visitation protocol. And we need to celebrate successes. This is all that positive reinforcement we have to give everybody. I mean, if we had to wait for total wins to feel good about what we're doing, man, we'd all be worn out all the time. Because our wins, come in little bunches if we're lucky. They're not real big wins at one time. They're little wins along the way. We have to celebrate those to keep everybody going, if nothing else. Again, just like the case plan we talked about this earlier, reasonable efforts, the case plan belongs to everyone as well. Everybody has a role in case planning, case implementation. The case plan should be driven by the identified needs of the family and not by readily available resources of the agency and community. We're going to talk about that in more detail in a few minutes. Peanuts. You guys know the Peanuts character, right? I'm a lot older than you guys. But these things were coming along all the time. I didn't read them when they were first coming out. But when Schultz is his name, right? When he died, the Atlanta Journal ran a lot of what they thought were his best. And I picked up on this one. And it really speaks, I think, effectively to case planning. Well, what happened was that Charlie Brown was in his backyard, and he had a wooden fence over here. And he would take a bow and arrow, put an arrow in, pull the bow back, and shoot the arrow into the wall. He'd run over there, he'd draw a bullseye around it, around the arrow in the wall. And Lucy, who I understand to be a bit of a busybody, comes running out. And she said, Charlie, you're doing it all wrong. He said, what do you mean? I'm doing it all wrong. She said, well, you're supposed to draw the target and then shoot the arrow. He said, but my way I never miss. Okay, funny, but what's it got to do with case planning? Everything in the world, in two different areas. One is in and choosing the permanency option for the child. What we want to do a lot of times as a system, not just as an agency, but as a system, is we want to pick the option that's the easiest to achieve, the most readily available option, whether it's best for that child or not. It's the same way with case planning. We're going to say, okay, here's this brand new service that my favorite provider has started, so mom needs to go to it. We got to fill those classrooms up because it's good stuff. Research-based, everything. It's funded, doesn't cost us much, if anything at all. That's not good case planning. That's shooting the air and saying that's the bullseye. We need to look at it. What are the specific needs that mom has, and what service will meet those needs is the way that we need to do it. Case planning begins the first moment the child welfare agency or system touches the case. I mentioned to you in our county we have our service plan that we begin developing at intake, assuming mom's in a condition to do that or dad. They may have fled the scene, they may not be there, they may be impaired. But if they can, we begin case planning at that point, and we get them into services as quickly as we can. Voluntary at that point, but they can oftentimes be sold to the parents. They're pretty vulnerable. A lot of times they'll agree to do just about anything at that point to get their kids back. Sometimes they won't even talk to you. The first important step in terms of case planning is to thoroughly investigate the case. That came up earlier when we talked about reasonable efforts to determine the reason the child can't be maintained at home safely. I mean thoroughly investigate the case. Thoroughly. When you think about what we're doing as a state is taking these children out of the home, we need to know everything we can about what's going on with this family before we make those decisions. It's the responsibility of the agency to dig deep in the history and dynamics of the child, the family, and the environment to determine the root causes of alleged deprivation. There's a tendency to focus on the precipitating cause of removal, the crisis, what happened just now, and build everything around that. And oftentimes that's just the tip of the iceberg. And sometimes it's not really reflective of what's going on in the home at all. So we've really got to dig deep into the history of this family, including the agency history with this family. Without a thorough investigation on the front end, permanency will be delayed as the underlying problems are discovered later in the process and the plan revised, or a child may be returned home prematurely and thereby placed at risk of a subsequent removal or worse. The court is the gatekeeper of the child welfare system. I had a case manager disagree with me one time about that, and that was okay. She felt like they were, and maybe I didn't communicate it well, but ultimately the judge decides which children come into the system and which children go out of the system. To that extent, we are the gatekeepers. I referred to her then as maybe on the sidewalk, and she didn't like that either. A different case manager, just a side note, a different case manager once, the county director shared with me an email that this case manager sent to her because I had made a comment in court about these being my children. And she sent an email to her county director, kind of complained about me a little bit, and said, doesn't he understand these are my children? And I love it. I think that's great that she has that kind of investment in her kids. I was not offended at all. The court should never consciously or through inaction abdicate its responsibility as gatekeeper. And we have the ultimate responsibility. And these are our decisions to make. It's your responsibility to give us all the information that we need to make the right decisions. The court should never accept stipulations of deprivation. This goes a little bit about what you're talking about in Cobb County. And by that, I'm saying that the court, it is perfectly appropriate for the court, after inquiry, to accept a stipulation of facts constituting deprivation, but not a bare stipulation of deprivation. Now, when I've said in other courts, I've seen that when I have an attorney come in from another county or circuit, I'll have them offer to stipulate the deprivation. If we say that the specific cause of the removal of the child from the home is a foundation for the case plan, what are we going to build a case plan around if we accept a bare stipulation? Allegations in the complaint? We can't do that. It's got to be based on a court finding. So court should accept stipulation of specific facts after inquiry to make certain there's a reasonable basis, factual basis to support the stipulation. And then, based on those stipulated facts, make a finding of deprivation. We've said this several times, we can't say it enough, that the foundation of a good case plan is the court's determination, the reason the child cannot be maintained at home safely. And that finding should be made at a 72-hour hearing, or if it's a petition filed without emergency removal, at the adjudicatory hearing. and reduced clearly to writing and put in the court order. And the finding should be based on evidence presented in court with full recognition the standard of proof is probable cause at 72-hour hearings. That's why sometimes it changes after the 72-hour hearing. And sometimes you have to amend the plan throughout the case. Even after an adjudicatory dispositional hearing, sometimes as new issues develop. Characteristics of a good case plan: simplicity, specificity, accountability, relativity, and doability. I made some of these words up. And they don't exactly fit the law, but they kind of do, and I'll explain that as we go through them. I had to make them rhyme, is why I had to use these words. This is just the dictionary I could pull off the internet one day because I didn't have a Webster's nearby. Simplicity means the property, condition, or quality of being simple, absence of luxury or showiness, plainness, absence of affectation or pretense. Georgia used the term clear. I converted that to simplicity because clarity or something didn't make any sense to me. It didn't rhyme. But clear and simple is basically the same thing. And we talk about a case plan being simple. Who are case plans written for? The parents. Right. And it goes back to offering services at developmentally and culturally appropriate levels or types of services. Right? So we need case plans that parents can understand, that are not too complicated, that are in words that they can understand. Because this case plan is written for them. I like the terms in there, absence of luxury or showiness. This is just the basic stuff is what we're talking about. Doesn't have to be anything fancy. Specificity, this is directly out of the code, that we have to have specific changes that need to take place and specific services to be offered. And I like this one too, this definition, because separate from the obvious definition, we have special, distinctive, or unique. Again, we said that case plans are developed for every individual case. They need to be individualized for the circumstances of every case and not boilerplate. And also intended for applying to or acting upon a particular thing. And we talk here about clear steps. They apply or relate to the changes we're trying to effect, which relate to the reason the child can't be maintained at home safely. It's kind of all tied together. Accountability. In order to have accountability, each component of the plan must be specific and simply stated as to what has to be done, must be specific and simply stated who has to do it, must be specifically and simply stated as to when it needs to be done. The analogy I use here, although they're getting a little old for it, is I've got two boys that are 28 now, but as early as they could walk almost, their mama made them be responsible for cleaning their room all the time. And you can say, okay, boys, go up and clean your room. That's one way to do it. So you go upstairs, and they come back down, room's clean. You go up there to tuck them into bed, you look at it, looks pretty clean. And then you kind of catch out of the corner of your eye something sticking out under the bed. Then this whole mystery becomes to unfold. And they've got toys stuck under the bed. They've got clean clothes that are just wadded up and stuck somewhere, dirty clothes stuffed in drawers. And, the first time that happens, can you fuss at them about it? Because you didn't tell them what you meant by clean your room, did you? You weren't clear and specific. You didn't say put the toys in the toy box. Your clean clothes folded neatly and put in the drawers. Dirty clothes in the dirty clothes hamper. Until you do that and speak in those terms, you can't really hold the children accountable. You can't hold parents accountable, lawyers accountable, judges accountable, agency accountable. So everything we do needs to be very specific and simple. Or you can't have any accountability at all. Relativity. This is what we talked about earlier. Is basically what the law says is there's a reason the children can't be maintained at home safely. There's specific changes in the child, the parent, the environment that must take place in order to allow the children to return home safely. And there's specific steps that must be taken to affect that change. It's all connected. I always wanted to learn that little song about the certain bones being connected to one another and kind of sing it at one of these, but I can't sing and I don't know the song. But that's the thing we're talking about. It's all connected. That's the relativity. One thing is related to the other. The things we're asking parents to do should be related to the change we're trying to affect. And that change should be related to the reason the child can't be maintained at home safely. Now we have a presentation I've done a couple of times, not in a lot of years, called Beyond the Checklist. And that's what happens when we've checked off all the list and done these things, and maybe we haven't affected that fundamental change in the way a family does business. It's a difficult part of our work. Doability. We talked about this a little bit earlier too, is that if you've got a case plan that you have developed that's a good case plan, unique to the facts in this case, and you take a look at that case plan, and you realize for one reason or other that mom can't do it, and folks, this is not a reunification case. And we don't need to wait 6, 9, 12 months down the road to figure that out. Nothing should be in that case plan that's not necessary to affect the change we need to let the child go home safely. So that means we can't leave anything out. So if we expect mom to do all these things and she can't do it, then we need to look at something else. This is not a reunification case. At least it's a concurrent case. But if we know she can't do it up front, why are we going to waste months and months out of this child's life giving mom an opportunity to fail when we know she's going to fail? It could be diminished mental capacity. Now, I've had cases over the years where I get to a TPR to find out that mom has a 55 IQ. That's not happened in a while, but I've had that happen. We should have known early on the things we expected of mom were never going to be achieved. I've had cases where we found out that we had a psychological that suggested that earlier too and didn't really come out till the TPR. That's another point about psychologicals. No, we don't need psychologicals in every case, but psychologicals are not always just about mental health, because one piece of all of them we get deal with intellectual ability and cognitive ability. And it gives us some indication of whether mom can do what we want her to do or at what level and where we got to go. We got to go where mom is to help her solve these other issues she's got. And it helps us tailor plans. So if there's any doubt about diminished capacity, we need evaluations. Just some general comments. We've already talked about that one. Okay, some people don't like this. We operate in a world of minimal standards. Some people don't like that. CASAs don't like that. A lot of foster parents don't like that. A lot of lawyers don't like that. A lot of people just don't like it, period. But we operate in a world of minimal standards. By that I mean that when parents can meet the minimum standards of care for their children in terms of safety, they got a right to have their children and the children have a right to go home. That's really the standard. It's not whether they would be better off living with this foster parent who has a lot more resources. It's not really about whether or not they can go to college, have a better chance at college if they live with these foster parents and grow up in foster care than if they live with their parents. This is a constitutional issue. And the parents have a right to have their children with them if they meet this minimum standard of care. Doesn't feel good, you don't like it. Anybody want to talk to that, by the way? I mean, I'm open to it, but I think that's the law. Doesn't feel good always, does it? I can tell you sometimes, even as a parent's lawyer, because I did it, it doesn't feel good. I mean, you do what you got to do, but you know the child has a better future in a lot of ways outside the home. That's not the standard. We talked about this earlier, but I want to say it specifically. Limitations which impair the ability of any participant to accomplish goals or to complete specific action steps must be dealt with in the case plan. Transportation being one of the most obvious ones. Another, in fairness, would be a resource issue for the department. You know, a judge should not absolutely insist on something being in a case plan that the department cannot provide after having made reasonable efforts to develop the resources. This is what we talked about earlier. I skipped ahead a little bit. And I want to say specifically, we touched on this, but no change should be required that does not reduce the risk factors that make it unsafe for the child to return home, and no steps should be required unless the completion of those steps is reasonably calculated to bring about the identified changes. That's not just a statement, it's not just my relativity thing, it's actually the law, which we'll cite in just a minute. We touched on this earlier, but I mean, you guys still seeing case plans where there are things in there that probably have nothing to do with safety? I still see some of those. I know when I first started, and every mom that didn't have a high school diploma had to get a GED. Because that child couldn't be safe at home if mom didn't have a GED. And I understand, as I said earlier, there is a page that you don't see in a lot of your case plans. Go back and look at some of them. It's called secondary goals, where we can put those things in a case plan. We can monitor those things. We want to do everything for mom that we can while we have her. But we can't keep her children away from her until she gets the GED. And a lot of other examples like that. And we're going to talk about some of those in just a minute. One comment is they overwhelm the parents so much that they're unable to complete the things that really need to be completed. We really overwhelm these parents a lot of times. We want them to get a job. Let's talk about that one in a minute too. We want them to get a job. When we go to parenting class every Tuesday night, substance abuse 3 nights a week. I don't know, probably something else, right? Pardon? Do visitation. And keep that job, by the way, because you got to have that job. And we really overwhelm them. What about, let's talk about this in a minute, because it's in almost every case plan. Has mom got to have a job? Source of income. Does she have to have a source of income? What's your list totally off public assistance? Source of income. But do you still see it in case plans? And is it a good thing for mom to get an education, develop some skills, and get a job? Absolutely. And we should support her in that in every way that we can. But we can't require that as a precondition of her getting her children back, if her children are safe at home. Again, I know some of y'all don't like that, but that's the case. And it goes back to the child support thing. If we really, really need to focus on child support, because a lot of these cases, we can keep these families together if we create a stream of income. And this business about requiring the parents to go to child support enforcement to get it done is not effective. It's not timely. I'm not saying they don't do a good job. It just takes longer. But we got dad there. Let's do a little child support worksheet and make him pay child support and create that stream of income. And the statutory authority for these comments is 1511-58C3. It says that all services and actions required of the parents which are not directly related to the circumstances necessitating separation cannot be made conditions of the return of the child without further review. The further review means that you got a case plan and you have to have further review to decide if those things are really appropriate or necessary. Questions to ask about every goal and every step. You could just do this in a bench card or in your private practice. Is it simple so as to be understood by all? Is it specific as to who, what, when, and where? Does it allow for accountability? Does it relate directly to the reason the child cannot be maintained safely at home? If all the steps are achieved, will the risk to the child be reduced to a level that will allow the children to return home? And this is kind of a test that you can apply to each case plan. And then is it doable? Then these are 2 critical questions you can ask for a case manager to ask before a case plan is submitted to the court. When the parents complete all the steps in the case plan, will you be comfortable allowing the children to go home? Is there any step in the case plan that, if not completed, will keep you from allowing the child to go home? Sometimes we find on the tail end that some things probably shouldn't have been there. Because I'll have a case manager come in and recommend the child return home, and we haven't completed a step. And maybe we've affected change through some other combination of things we're doing. And maybe that step specifically was not necessary as it turned out. It's easy to look at this stuff, in hindsight. We know how important time is to children. And I alluded to this earlier, but in case planning, one of the things I really just don't like to see is that the case manager is going to schedule a psychological, he's going to schedule a substance abuse assessment, whatever it may be. The case manager is going to do something, down the road, even if they have a specific date, which is good. If they got a specific date, that's a good thing, within 2 weeks. But the question is, why don't you schedule it? Why don't you schedule it then and put it in the case plan? Because what happens so many times, you're going to have mom there signing off on the case plan. What happens so many times, if we don't do it, then we get it scheduled, right? And I'm sure even some of you parents' attorneys have a hard time finding your clients sometimes. So do case managers. So do deputies to serve them. Sometimes they're just hard to find. So you schedule that psychological for next Friday. And you go by and mom's not there, you leave a card. Go by, leave a card, go by, leave a card. And now you've missed the appointment. And you've also stood up a counselor and made him or her really mad about that. Schedule as many of those things as you can and put them in the case plan while you're doing it. It doesn't take any more time. It saves you time. I promise you. It will save time in the long haul. There's nothing that we do early in these cases, if it's necessary, that we're not going to have to do at some point in time anyway. And it's far more efficient to do it early on in the case. Relapse planning. That's a much neglected piece of our work. And we need to work and have a better relapse plans. So that, relapse is a reality of addiction, all right? Everybody understands that. And one thing we have to do is build trust with the parents. And it's probably easier to do this. How many of you work in or practice in a court that has drug courts? A good number of you. It's probably easier to do that in that kind of environment than if you don't have it. You have more frequent contact with the parents. It's more of a kind of a team concept than necessarily normal court hearings. But you really need to build trust between the court and the parent and the system and the parent, and acknowledge that relapse is a reality of addiction. And when I let parents go with their children, and we've had a drug issue, then we talk about that. Sometimes. I can't say I always do it, but we talk about it. We particularly did it in our drug court when we had that. And it's important to let them know that if they relapse, that happens. But the safety of the children is what's paramount. And if you have a relapse plan that ensures safety of the children, and you do what you're supposed to do under that plan, we're going to work with you to keep your children. Because they're afraid that we're not. And that's why, even when you have a relapse plan, a lot of times that's why they don't follow through on their plan, because they don't trust us. Catherine West, a psychologist in California that ran a treatment center, had a plan. She gave an example of a lady, and in her relapse plan, if she felt just the need to do drugs, and she felt like she could not resist, then what she had to do, she had a relapse partner. It was I don't know if it was a family member or a friend that agreed to be her relapse partner. So it sounds kind of weird because she's going to be a partner in the relapse. That's not what we're talking about, really. But what would happen is that when mom just knew she was going to do it and could not resist, she would call her relapse partner and tell her she was going to do it. And then what she had to do is she had to pack her baby's clothes and take her baby to a relapse partner. Sometimes they did it. But she told a story about one lady who wound up clothes packed, locked herself in the bathroom, crying like a baby, and called a relapse partner and said, "You need to come here, I can't do it." And they were able to intervene. The worst case is mom relapses and the child's safe, if this thing works. And sometimes mom just doesn't relapse because of that plan. We need to focus more on, in our case planning, on relapse. And when I say that, that's a service provider issue to a large extent. We need to make sure our service providers are putting those relapse plans in the work that they do. All right, I'm not sure where we're on the time. We're about to move into section 3. Would it be better to start or take another break, Michelle? Yeah, questions on, yes ma'am. I've got one back here first.
Judge, I wanted to ask you about, you said the 2 critical questions before submission of a case plan to the court.
Right.
And you spoke about when the parents complete all of the steps of the plan, will you be comfortable allowing the children to go home? Now, what about in cases of domestic violence, when they've completed everything that's written down, but you're still kind of seeing some areas where they may not really be serious about this?
Yeah, that's a really good question. And it's not just a domestic violence, but a lot of issues too. And that goes to the other presentation that I've done before that is called Beyond the Checklist. What we really have to affect is a fundamental change in the way the parents do business or a fundamental change in the environment. And ultimately, we have to make the assessment of whether we've done that. And that's why a lot of case plans will say that mom has to use non-harmful methods once the child's returned home, as an example. Well, you can't, that shouldn't be a reunification plan because you're not going to know that until the child goes home. You've got to have a way of having mom demonstrating those non-harmful methods. And it's the same way in domestic violence and substance abuse. But you ask about domestic violence. If we're at that point and mom has completed the treatment that we anticipated for her, and we still don't think that she fully understands how to apply what she's done, we've got to revise the case plan. Now, we may at that point, depends on where dad, it shouldn't be dad, where the perp is. There may be a new perp coming too. But we may be able to, hopefully in most cases, still return the child home to mom safely, continue to work with mom, continue to educate mom, continue to condition her to make the right decisions. It's a very, very, very complicated issue in substance abuse and domestic violence as well. But that's a very good point. The point is, if we know up front, though, that if she does these things, we're not going to be happy with her going home. We've got to rethink it up front. There was a question here. He's coming with a microphone.
Judge Key, I wanted to thank you so much. You've been such an encouragement already. I'm brand new at this. I'm a new attorney and an old registered nurse, and I appreciate your comments about the parents' constitutional rights, because coming into the system, it's been appalling to me to sense the attitude that almost these folks taking the kids away are the ones with all the rights and the parents are the bad guys all the time. And I just appreciate you accepting the fact that they do have a right to their kids. But what I wanted to ask was that 30-day time frame from the case plan being prepared. I've come across a SAG who's telling me it's 30 days from the time that the agency who's preparing it gets the referral, and not 30 days from the time the children are removed from the home. Can you clarify that?
Well, you know, I'm going to plead ignorance on this, and I'll tell you why I'm ignorant about it. I was challenged on this the other day, is it may be 30 days from the day child enters foster care. I'm not certain. I don't think that's right, though. But we run every time frame for physical removal. And if I want to do teaching, I should probably pull the code out and look at that. But we run everything for physical removal because they're shorter time frames. We run panel reviews, all the periodic reviews from physical removal, not from the day the child entered foster care, not from adjudication, all those other definitions. One thing, I'm not smart enough to figure out all those time frames. But also it tightens the time with the child in care. Now, some other people may know the answer to that exactly. So what about you guys? Is it 30 days from physical removal? 30 days from what day? What triggers it? Physical removal? Okay. So, and that's kind of the way I always thought it was, but I've done it that way for 21 years. And can't remember exactly what the code says about it, but I got at least one other person who thinks that's right. And I encourage you to use the shorter time frames. You can't go wrong with shorter time frames. Now, I will tell you that federal law is 60 years. I mean, yes, 60 years. Seems that way sometimes. 60 days is federal law. It's asked for, but Georgia adopted a 30-day rule. Other question? Yes, ma'am.
I was wondering how you reconcile the statement that plans should be driven by the needs of the family, not the availability of services, with the idea that a case plan should be doable. Like, if mom and dad need therapy but they don't speak English and there's not that counselor in our area or transportation, do you put that step in the case plan knowing that it can't be done, or how do you reconcile that?
Yeah, that's really a big question because it talks about the culturally appropriate services and a lot of other things we talked about. We have, I don't care what your developmental level is. I don't care what your nationality is, your culture is. We have a responsibility, if we take your children away from you, to make reasonable efforts to provide services that are appropriate. And that's not always easy. I know I'm told by some of our rural judges that may have as many as 5 or 6 counties that there's not an English-speaking psychologist in those 5 or 6 counties, much less someone that speaks other languages. So it is, again, it's a reasonable efforts issue to attempt to develop those resources. If you live in a county with a very small, well, let's use my county as an example. I don't know that we have any German-speaking person in my county that does not speak English at all. So I would not be expected to develop, and not expect the agency to develop resources for a German-speaking case. But we have a growing Latino population. So we are addressing those issues to have service providers. And the department knows of some service providers that in fact do speak the language, different languages. But we can't provide those kind of resources in every county that doesn't need them. In some counties we have large populations of other nationalities. And if they have a lot of those cases, they need to develop the resources to meet the need. From our standpoint, we still got to meet it. We still got to meet the need. We might have to bring somebody in. We may have to transport the parent to Columbus as an example, where we're probably a much more multicultural community than LaGrange. But we've got to make the reasonable efforts to meet that need. Can't meet it in every case. One in the back. Oh, microphone coming. Oh, don't ask me an ICPC question.
Well, I think you'll be able to answer it. At the national level, is there any discussion of ways that they can expedite the process or make improvements on getting them done more quickly? And then also, as a follow-up to that, what do you think of the use of CASA complementary home visits that are done by CASAs in other states as a basis for sending children to live with relatives out of state?
These are tough questions. I'm not dodging the question. I've got somebody who wants to answer it right here, I think. But before we do, Michelle, can you tell me a little bit what's going on with ICPC in Georgia?
Oh, you mean just, I think she's asking you a bigger question than that, though. I mean, what, if anything's happening? Well, in the national scene, they're talking about
Yeah.
rewriting it.
Right.
But then locally, yes, we're just trying to get through some of the bureaucratic barriers we're trying to work with Florida and get more things automated. Why the Florida ICPC administrator was in our state office, I guess a month ago, and he said that every Monday morning, about $60 worth of mail is put right in front of his office. It's from Georgia, because we have a lot of cases between Florida and Georgia, and so $60 we're spending that every Monday to do that, and he says it goes up from there. But why can't we scan it in and send it by email? Well, there's just a lot of bureaucratic barriers there, but we've overcome a lot of them, and we just started. Well, actually, I give all the credit really to Judge Brett Hammond because I haven't really done that much on this. I've just been in the room. But we've been able to, just by working out through some protocols, because it's just hard to get past that stuff, we are now able to at least scan that stuff in and send it back and forth between Florida. Now we're going to work with Alabama. And then we're going to work with South Carolina and North Carolina. But that's just someone sitting through that and hammering through those rules and getting past that stuff, because if it's written this way, our culture can just get stuck there. I don't know if that's what you were looking for. Those are bureaucratic barriers. It does shorten about 30 days, though, when we start scanning things.
There is a national discussion going on. Are you familiar with it? You raised your hand. Were you going to answer that question? We can look at the mic over here, because I had a hand go up just like this, so I'm going to ask her to answer that question first, and I'll tell you what little I know about it.
I was going to comment that Judge Hammond from the Toombs Circuit has been working on border agreements for ICPC with Carolina, which is basically what you were saying. He's my juvenile court judge, so I was aware of it.
There has been movement on the national level. This has been going on for 3 years or so, and I think there was some momentum that has been stalled, is my understanding, and we don't expect a new compact anytime soon. Is that what you understand, Michelle?
I think we had said there's more problems with it, actually adds more bureaucratic barriers than we currently have now, so a lot of states have backed away from it. Do you want to talk a little bit about Regulation 7, though? That can be used to expedite certain cases. Under certain circumstances, you can use that as a tool to get the case moving.
Yeah, Reg 7 provides for expedited evaluations in limited circumstances. They're not useful in adoptions, as an example, and some others, but it is available. The National Council actually has a manual on ICPC, has a section on Reg 7. Now, what I find is most case managers are not familiar with Reg 7. And we've trained our court personnel on it, and we use it occasionally. We're a border county with Alabama, and we use it occasionally, but not a lot. It requires a good bit of follow-up. It requires judicial involvement, at some point actually judge-to-judge conversations, which is a good way to resolve these anyway, a lot of times.
When we post this presentation, we'll put that as part of it, just to answer
Right.
this question. So we'll put a link to that Regulation 7. We've used it once in a case not too long ago to try to expedite a case, or expedite a young child to move across the border, and the judge heard it and it worked.
There are age limitations and things like that. The CASA issue, I may halfway dodge that one too, because we don't do that in my county. I will tell you that in my county, I get great CASA reports. I have absolute confidence in the CASA reports that I get in their presentations in court. In terms of the quality of the investigation and their findings, I would accept that as well as I would anyone else. I've just not thought through the issue about going across state lines to solve the problem. It is probably in contravention of ICPC to do that if you don't go through ICPC to do it, and I don't think you can. Also, I don't think that that's within, in terms of what national CASA allows them to do. I could be wrong about that.
And I guess
There's some liability. Is that your understanding as well? There's some liability issues. The national CASA does not support them doing those home evaluations.
And let me just say, we just did a review this morning, which is why it's fresh on my mind, where it's like three children who have been in foster care, because we have this project we call the Cold Case Project, where we're looking at cases of children who have been in foster care for over 2 years. And this one particular child has been in foster care for 10 years. And he entered in really young. And he was placed with a relative, and they skipped ICPC. And it made a lot of sense at the time. It looked right. But there were 3 young children that came in with some pretty bad facts. And about 2 years later, things started unraveling for this relative, who did show up and say, give me those children. It was a reasonable thing for the judge to say, fine, take custody, you don't need anything. But 2 years later, these problems did develop, and they could not get any services. So that aunt drove those 3 children back to Georgia, put them back in the same county, and they re-entered foster care. And since then, she has gone back home and sold her house, but it's taken 10 years to resolve all this. Now she's probably going to live in Georgia, and they're going to put the children back with her. But we paid 10 years of foster care for this. It's kind of a case of maybe we shouldn't skip ICPC. It's kind of a warning. I'm going to use it as a kind of an example case.
So certainly there's work that needs to be done on it. It is on the national agenda, not just for the National Council, but for most of the national organizations. But I don't see a solution in the near future. Other questions, comments? All right, let's take 15-minute break. Okay, thank you all.